Hi guys, welcome back to my lecture series on intellectual property rights. And in this video, our focus is on surrender and revocation of patent, and it is described in section 63 and 64 of Indian Patent Act. So far, while discussing the patent process, we discussed that patent applicant will be applying for a patent and then he will get the patent and all these things. But in this video, how can a patent holder can surrender his patent, or in certain cases, patent office will revoke involuntarily the patent rights of a party. So let us see these two concepts. What is surrender? Surrender is a voluntarily voluntarily a patent holder or a patentee will submit application to a patent office. So it is a voluntary submission of application. So voluntarily patent holder will submit application to a patent office for a cancellation of the patent registration. And revocation is a involuntary withdrawal of patent by the patent office. It will be withdrawn by the patent office. Here, patentee will not initiate anything. Okay, let us see what are the grounds that a patent office can revoke it. And before seeing into that, let's see what is surrender of patent. Surrender of patent is a simple process. If a patentee holder wants to surrender his patent rights, he will go and submit its application that we wants to surrender the patent, and it will be reviewed by controller, and controller will give a public notice on that person is interested to surrender his patents, and then it will go for any opposition and one more time of review, and finally patent will be revoked. These are the steps which are provided in section 63 of Indian Patent Act. So very simple process here. Voluntarily, a patentee will submit his application for cancellation or for revocation of a patent. This is possible only when a patent holder feels that his invention can be used for a broader public usage and other things. In those cases, a patent application will be submitted for surrender. Simple process, okay. And now let us see revocation of patents. It is not as simple as our surrender process. In this case, patent office can initiate the revocation proceedings with uh, patent holder. What are the grounds on which a patent office can initiate these proceedings? It is simple process which we know, sorry, simple reasons, because this we discussed while opposition grounds or even when which is not a patent. All these grounds are almost similar. So in the following cases, government or a patent office can initiate proceedings of revocation against a patent holder. What are those few cases? Let us see that. One is a duplicate. If patent office comes to know that there is already a existing complete specification document which is similar to this, then it can be revoked. Or if the given application is not entitled for patent under the provisions of this act, if it was obtained through wrongful ways, if it is not an invention, the subject matter which is claimed as part of complete specification document is not at all an invention under as per this act. If the document whatever is submitted, complete specification, if it is already known to a public in India large, okay, and if the document contains any, if it is not it is not an inventive step, okay, then also it will be called as it will be call for revocation. See, what happens is government patent office has already registered it, but after that, if they come to know that this is a duplicate, if it is not, it is obtained from wrongful ways, if it is publicly known, or if it is not an inventive step, then they can revoke it. Initially, before granting itself, they were knowing, then these all are pre-grant oppositions, and then there itself they can hold it. If it is after granting, if it comes, okay, then also they can revoke it. If there is no clarity, if there is some false representation on the subject matter, if subject matter is not patentable at all in Indian Patent Act, and if the topic or a subject matter of patent is a secret usage directions, if complete specification documents contains partial information, and if government orders under Section 35 that if it is a secrecy matter, then or if it is there is any fraud in the overall process, all these cases, if directly a patent office can initiate a revocation proceedings. And in some cases, High Court can revoke it based on the central government's request. Okay, central government if raise a petition that this particular patent should be revoked, and High Court will conduct an inquiry, and based on that, if High Court is satisfied that uh, the patent holder or a patentee as a reasonable clause failed to comply with the request of the central government. See, whatever the cases, in certain time, central government can use those patented inventions for the public for the benefits of public at large. If they were not able to do so, then the central government can give a direction to High Court, and High Court can, if High Court satisfied with that, then they can revoke the patent. What is the revocation procedure? I told the first the patent will be granted and it will be published. Okay, so once the patent is granted, when it is all published, if patent officer comes to know that, or a patent controller comes to know that there are some kind of there are few reasons for which the patent can be revoked, then revocation petition will be raised in Intellectual Property Appellate Board. And if the petition is overruled, then the writ petition will be filed directly in High Court. Okay. If the petition is not overruled, the revocation proceedings will be initiated and the discussion happens, and finally the decision may be for revocation. If there is a revocation, then the notice will be given to the party that the petition, your patent application is revoked. The aggrieved party, he can go to a appeal with High Court. The same way, if the decision is given in favor of the patentee and if the revocation is not granted, then patent board can go for an appeal. Okay, clear? The decision might come that it is in favor of the patentee, so there will not be any revocation. In that case, patent board will go to a patent officer will go to a appeal if at all required. If patent officer wants to go for appeal, they will go for it. Otherwise, the other decision, which is revocation order, if court gives it, then the patentee can go for a appeal. Clear, guys? Simple procedure. Once the patent application is initiated in IPAP, if it is overruled, then directly patent officer will go and raise a writ petition in High Court. If it is not overruled, then revocation proceedings will start and the decision may come in favor of the party where there will be no revocation. In that case, patent officer will go for appeal. The other decision which may come up is an opposite of it, where IPAB will give revocation order and then the notice of revocation will be given to the party. The patentee can go for appeal here. Okay, guys, that's it on process of surrender and revocation of a patent. And in the next video, we will discuss about rights of patentee under Section 48 with exceptions. Thank you so much, and don't forget to subscribe our channel Parva Media.